Have you ever felt like justice comes with a price tag you just literally cannot afford? Well, you are definitely not alone. Legal costs present this massive and sometimes totally insurmountable financial hurdle for everyday people who are just trying to navigate the court system. So today, in this explainer, we're going to unpack a comprehensive, step-by-step guide on how to apply for a court fee waiver in North Carolina. Because honestly, financial constraints should never lock you out of the justice system. It's a really daunting question, isn't it? When you're already dealing with the overwhelming stress of, say, an eviction, a divorce, or a small claims dispute, suddenly realizing that you have to pay hundreds of dollars just to walk through the courthouse doors, well, that can cause some severe financial anxiety. But here is the empowering reality. North Carolina law actually has built-in mechanisms to help. If you know how to use them, court fees absolutely do not have to stand between you and your legal rights. Okay, let's take a look at what we're actually up against here. These are the baseline costs of seeking justice in North Carolina right now. If you want to take someone to small claims court over a dispute under $10,000, that's $96. A standard civil district court filing jumps up to $150. Trying to clear your criminal record with an expunction petition, $175. And filing for an absolute divorce will run you $225. And by the way, that doesn't even include the $30 sheriff's fee for serving the papers. Seeing these numbers really validates exactly why fee waivers are so incredibly critical. So here is our roadmap for today's explainer. Navigating court fee waivers, who qualifies for relief, the step-by-step process, review, decisions and outcomes, special cases and resources, and finally our conclusion and legal disclaimer. Let's jump right into Section 1, Navigating Court Fee Waivers. Understanding the statutory safety valve. First up, let's demystify a pretty intimidating legal term that you're going to see plastered all over these forms, and that is indigent. Under North Carolina General Statute 7A 450, an indigent person simply means someone who lacks the available, adequate funds to pay the necessary costs of their legal action at the exact time those fees are required. So you don't have to be completely destitute, right? You just have to prove that paying these fees right now would effectively prevent you from accessing the courts. Now, here is a really crucial nuance we need to cover. A fee waiver in civil court usually operates as a suspension of upfront costs, not necessarily a permanent forgiveness. So what does that actually mean for you? It means you don't have to pay to get your case started. But let's say you win your case and the judge doesn't explicitly order the other party to pay the court costs. Well, the court might eventually come back and require you to pay those suspended costs out of your winnings. It's basically a delay to ensure access rather than a total free pass. Moving on to Section 2. Who qualifies for relief? The legal criteria for indigency status. Under Chapter 1, Section 110 of the North Carolina statutes, court clerks use a dual-track framework to evaluate waiver requests. First, you've got the mandatory categorical track, which is essentially an automatic qualification. And then there's the discretionary track, where a judge or a clerk has to look at your overall financial hardship and make a subjective decision based on the math. Let's look a little closer at that mandatory categorical track. If you currently receive supplemental security income, food stamps, or work first family assistance, or if you're being represented by a legal services organization like Legal Aid of North Carolina, for instance, the clerk of Superior Court is legally obligated to grant you indigent status. There's no further financial scrutiny. You basically just check the box, sign the oath, and boom, the fees are waived. But hey, what if you don't receive those specific public benefits? No worries. You can absolutely still qualify under the discretionary track. This track requires you to fill out Form AOC CV 226, which is an affidavit of indigency. On this form, you're going to detail your average monthly income, your existing debts, and your necessary living expenses. If the math clearly shows you lack the funds, the court can grant your waiver. All right, Section 3, the step-by-step process, gathering and filing the necessary paperwork. Your very first task is simply locating the correct forms, which you can do online at the North Carolina Court's website or right at the courthouse. You're primarily going to be looking for Form AOC-G-106. That's the actual petition to proceed as an indigent. And if you aren't on public assistance like we just talked about, you'll also need that affidavit of indigency. That's CV 226 for civil cases or CR 226 if it's a criminal case. So here are your chronological steps. First, obviously, obtain the forms. Second, calculate your monthly averages. And guys, it is incredibly important that you're accurate here. Don't just guess. Third, and this is super vital, you absolutely must sign these forms before a notary public or a court clerk who is authorized to administer an oath. You're literally swearing to the truthfulness of your financial situation under penalty of perjury. Finally, file those documents with the clerk of court in the county where your case is happening Naturally, there are some common procedural pitfalls that trip people up, and we want you to avoid them. The absolute biggest mistake? Forgetting the notary's signature. Another trap is not bringing enough copies. For example, Wake County strictly requires 1 original plus 3 copies of your family court documents, and they are not going to make those copies for you. Also, just a heads up, if your waiver isn't approved or you end up having to pay a partial fee, North Carolina courts generally do not accept personal checks. You got to use cash, a money order, or a credit card. Section 4, Review, Decisions, and Outcomes. What actually happens after you file the petition? Once you file, a judicial official reviews your paperwork. Now, this can vary slightly. For incarcerated individuals, a superior court judge actually has to review the underlying complaint, just to ensure the lawsuit isn't completely frivolous before they'll authorize the fee waiver. But for everyday civil litigants, the clerk is mostly just checking the math on your financial affidavit. So, what are the potential outcomes? Well, if you're approved, great, you proceed without prepaying. If you're denied, the next step is simple but obviously difficult. You have to pay the standard court costs to keep your case or your appeal alive. And again, always keep in mind that post-trial recoupment. Being indigent today doesn't totally insulate you from the court ordering you to pay those fees at the very end of the trial if your financial situation improves or if you win a monetary judgment. Which brings us to Section 5, Special Cases and Resources, Navigating Unique Legal Tracks. The rules actually diverge quite a bit based on the type of case you're involved in. In juvenile delinquency proceedings, juveniles are conclusively presumed indigent right off the bat, so no financial affidavit is required for the child. For adult criminal cases, waiving true court costs requires a judge to find just cause. And if you're convicted, the court actually enters a civil judgment against you to recoup the cost of your court-appointed attorney. On a completely different but very important note, domestic violence protective orders are entirely exempt from filing fees. You don't even need to fill out a waiver form to seek safety. To make this whole process a lot easier, there are some incredible free resources out there. Law Help NC offers these online guided interviews that basically just ask you simple questions and then automatically generate your completed forms. Plus, the state provides translated versions of these forms in Spanish and Vietnamese, which significantly increases accessibility for non-native English speakers. Finally, Section 6, Conclusion and Legal Disclaimer. Some final thoughts on accessing justice. The fundamental takeaway of this entire explainer is clear. North Carolina law deliberately includes a statutory safety valve. The system is intentionally designed so that temporary financial constraints do not completely block your access to the courts, whether you're trying to get a divorce, appeal an unfair eviction, or clear a past record. Of course, as with all legal matters, we've got to state our disclaimer. This explainer provides general information derived directly from North Carolina statutes and legal aid resources. It is definitely not a substitute for personalized legal advice. We highly, highly urge you to consult with a certified legal professional or a legal aid organization for guidance that's actually tailored to your specific situation. So, I'll leave you with this one final thought. Now that you know these tools exist, you know the forms are accessible, and that the law literally has provisions to help you out, are you going to let court fees stand in the way of your legal rights? Or are you ready to take the next step? Thank you so much for joining us for this explainer, and we really hope this knowledge empowers you moving forward.